Well, good afternoon, everyone. Thanks for joining us. My name is Stephanie Ott. I'm the Director of the National Sea Grant Law Center, and this is the July webinar as part of our webinar series. And today we are focusing on our water research, which is also relevant to the National Sea Grant Program's 50th anniversary because the focus is on water this month as well. And so just a few things to mention. You are muted right now, muted on entry. If you have a question during the course of the webinar, please feel free to use the chat box to enter your question, and then we can answer them after the presentation. And for now, I'm going to turn it over to Tara Bowling and Catherine Janessy, who are research counsels with the National Sea Grant Law Center, and they will be running the presentation today.
Hi, everyone. This is Tara Bowling, research counsel at the National Sea Grant Law Center. Thanks to everyone for joining us today. As Stephanie mentioned, Kathy's done quite a bit of research on water law over the past couple of years. So we're going to go through some of what she's been working on. So first of all, Kathy, what projects has the Law Center been working on lately?
So the last year, we've actually been looking a lot at both water quantity and water quality issues, which has really been triggered by some current events that I'm actually going to go through in this webinar. Most importantly, to us here in Mississippi, the state of Mississippi suing the state of Tennessee over water quantity issues, and then we've all kind of seen the Flint issue in the news and issues with lead. So those are the two main topics we're going to try to cover today, is kind of how water is allocated, how are interstate disputes determined, and then kind of looking at some of the research we've done with the state's Drinking Water Act.
Sounds great. So Kathy, what is water law?
So water law is actually a term of art in the law, and it refers to how fresh water is allocated. And so it determines who gets to use water and for what purpose. And water law is mostly state law. So states themselves get to determine their own rules on how to allocate water within their borders. It's mostly a system that focuses on use and not necessarily conservation. So what matters under the law is who is using water for what purpose, and some uses are more protected than others. So for instance, domestic use, which is us using our own water in our own house, is more protected than other uses such as industrial or agricultural uses. And water law is also an area of law that's split in a couple of fundamental ways, as surface water and groundwater are governed by two separate sets of legal principles. So for groundwater, the rules vary by state under a handful of different legal doctrines, but for surface water, we see this stark regional difference. And interstate water bodies are also treated differently.
So how is surface water regulated?
So when you're talking about water law, it's important to note that the water laws and policies in the United States have been split into two major areas, the wet eastern states and the dry west. So the West has always had water supply issues, and a legal doctrine known as prior appropriation developed to deal with this scarcity. So in the prior appropriation system, the state issues water rights to users on a time-based priority basis, as a certain amount of each waterway is doled out to individual users. So you can think of those users in line with a bucket of water at a stream, and so each person gets to fill up their bucket with the amount of water the state has given them. Then the next person gets to fill up their bucket, and on until everyone the state has given a right to gets their turn. But if the stream goes dry by the time your turn comes up, you're completely out of luck. So your right is completely contingent on whether there's any water left to give. So how does the system work in practice? If you're kind of thinking about the Colorado River and imagining it as it's flowing through the Grand Canyon, this is actually a picture of the Colorado River before it makes it to the Pacific Ocean, and you'll see that it's completely dry. And so this is a circumstance that happens a lot in the West, is that there's many rivers and streams that have no water left in them at all. Now you can compare this to the East, which has always been viewed as water rich, and the law recognizes this in that part of the country. So those who live on waterways are considered riparians, and everyone can use the water how they like, as long as the use is reasonable and it doesn't affect the other users. So this means until there is a problem, there's very little monitoring or control over how much water you are using. But as the eastern United States starts to face water scarcity issues, problems with the riparian system are emerging.
Okay, so is groundwater regulated differently?
It is, actually. And a part of that, as I'll get to, is because we can't see it that well. So when we all picture water in our head, we're thinking of things like rivers and streams, and we're thinking that the earth is completely covered in water, which is what we've always been taught in school. But in fact, only 2.5% of the world's water is actually usable fresh water, and of that 2.5%, only 1.2% of that is actually surface water, and the rest is actually either glaciers, which are trapped up in the ice caps, or groundwater, which is 30% of our water. And so this 30% of the water has its own set of rules that are distinct from the rules governing surface water use. Here with us in Mississippi, we actually get over 90% of our water from groundwater. And so the issue comes is that most water policy is developed around surface water. So surface water is easier to manage. We know how much water is there and when it will run out. It's easy to see overuse because the river or stream runs dry. So states get to choose what groundwater doctrine they wish to follow, and there are a handful of doctrines that they can choose from. But with almost all doctrines, since we historically could not see groundwater resources or understand their dynamics, we have allowed them to use their rate that exceeds their natural replenishment rate. And if you add this to the fact that many places have enough groundwater to supply desired uses for long periods of time, these kind of create us the illusion that the resource was limitless. Unfortunately, as we're now seeing with our aquifer use, when we overpump groundwater, there are serious consequences, such as the need for deeper wells to access water, subsidence, environmental impacts, and saltwater intrusion.
So do these rules apply to interstate water disputes?
So they actually generally do not. So interstate water disputes are common, and so sometimes states can negotiate agreements as to how to share water resources that cross state borders. But when there are disputes, they can only be resolved by the Supreme Court of the United States. So the Supreme Court has original jurisdiction in all cases in which a state is a party. In suits between states, the Supreme Court actually serves as a trial court instead of as an appellate court as it usually does. So typically the court appoints what is known as a special master that hears and evaluates evidence, prepares findings of fact and conclusions of law, and recommends a decree which the court is free to follow or disregard. The decree and adjudication of the case is actually binding on all claimants to the water in question, even if they were not actually parties to the suit.
So what law does the U.S. Supreme Court apply?
So the Supreme Court has actually developed common law to resolve disputes over the allocation and pollution of interstate rivers and other water bodies through a doctrine called equitable apportionment. In doing so, as I said earlier, the court is not bound by the laws of the individual states. So state law will inform their decision, but it's not controlling. The court has stated that equitable apportionment is a flexible doctrine, and it will consider all relevant factors of the case, as well as the harms and benefits to each state, so that a just result is reached. So the basic tenet of the doctrine is equality of right, not equal amounts of water. So if you're thinking about how the court will split this up, you can think about the states being seated at a table, each with a glass, while the court holds a pitcher of water. So the court will pour out the water, telling each state how much they get. But as I said, the court isn't just going to split this water equally. It's going to take certain factors into account. And in doing so, it's going to do this balancing test of these benefits and interests versus harm. And the court also wants to avoid extremes, so they don't want to reach a decision that might completely exclude a state from using a water body in its own territory.
So, Kathy, what's happening with the recent Florida versus Georgia case? Is that connected to the previous tri-state water wars that we heard about?
It actually is related. And so the most recent case is an attempt to address the long-term viability of the oyster industry in the state of Florida. And so the state of Florida has filed a lawsuit against the state of Georgia. And so the lawsuit is seeking injunctive relief from Georgia's upstream water use And as I just said, the newly filed lawsuit is another chapter in this long fight between Georgia, Florida, and Alabama, which is known as the Tri-State Water Wars, and it's over Georgia's use of water for the Atlanta area. So Florida is asserting that Apalachicola Bay needs more fresh water from Georgia, and they believe that the bay needs, in particular, this increased water flow from Lake Lanier, which is a lake that has been created by the completion of Buford Dam up in Georgia. So Buford Dam is located north of Atlanta and was built by the U.S. Army Corps of Engineers across the Chattahoochee River, which created Lake Lanier. So North Georgia uses the dam and reservoir for many uses, such as for water storage, flood control, hydropower production, and recreation. And at the time of the dam's completion in 1957, municipal water supply actually was not considered to be a main use of the dam. But as the populations of Atlanta and North Georgia has grown, the Corps in Georgia began to increase their withdrawals from Lake Lanier through a series of contracts under the authority of the Water Supply Act. Most of these contracts actually expired way back in 1990s, but the Corps has continued to permit these water withdrawals from Lake Lanier. So these increased withdrawals is what has led to years of negotiations and lawsuits between Georgia, Alabama, and Florida. And in particular, Alabama and Florida have continually questioned whether the Corps could reallocate the dam's conservation storage to municipal withdrawals.
So what exactly is Florida upset at? What specific complaint about in this case?
So Florida is mostly upset in this case about the status of its oyster industry in the Apalachicola Bay. And so while there may be multiple causes for the decline of oysters in the area, Florida agricultural officials believe that the drought is a contributing factor. And while this is important, is that oysters need the correct mix of salt and fresh water to survive. And so changes to the water level of an area, including drought, affect the salinity of the water and may adversely affect oyster populations. So Florida wants the Corps to equitably apportion the ACF River Basin and to enjoin Georgia from preventing an adequate flow of water into Florida's Apalachicola region. So Florida has emphasized that both previous court cases and the non-judicial negotiations between the states have failed to settle the controversy surrounding how to manage the ACF River Basin. Meanwhile, Georgia is claiming that Florida has failed to sufficiently show that it has suffered substantial imminent harm to its sovereign rights. So Georgia thinks that Florida has not adequately alleged harm or tied its injuries to Georgia's water use, that it has not really connected Georgia's water use to the damage to the oyster industry, and that Florida has neglected to note the fact that about 70% of the consumption of the water, Georgia is actually returning back to the Chattahoochee River.
So the Mississippi versus Tennessee case has been in the news as well. What are the issues there?
So Mississippi versus Tennessee is actually a pretty intriguing case because the court has never decided an interstate case solely about groundwater. So currently Mississippi and Tennessee are in a dispute concerning groundwater from the Memphis Sands Aquifer, which is on this map, and you all can kind of ignore that area in yellow. It's not important to the point of what I'm trying to make here. I just wanted to get a map for you all to see the aquifer. So the aquifer underlies both states, including Mississippi and Tennessee, and Mississippi and Tennessee both pump water from this aquifer. The issue is that the city of Memphis, which for those of you who don't know is right on the Mississippi and Tennessee border, pulls their water pretty much at the borderline. And so Mississippi has challenged this use before by suing the city of Memphis for monetary damages. So back in 2009, the Fifth Circuit Court of Appeals dismissed Mississippi's lawsuit, ruling that Mississippi had framed its case incorrectly. The court determined that the aquifer was an interstate resource. So Tennessee, which was not named in the suit, was a necessary party. Further, since it was an interstate dispute, original and exclusive jurisdiction belonged to the Supreme Court of the United States.
So what are each state's arguments?
So the states of Mississippi and Tennessee have very different theories for this case. Tennessee, in referring to the past Fifth Circuit decision, is claiming that water is an interstate resource, and thus the court needs to determine how much each state is entitled to. Second, Tennessee is arguing that there is no present injury to Mississippi because there's still enough water in the aquifer for both states to use. However, Mississippi is claiming that Tennessee is actually pumping water from under Mississippi, and that this water would never leave Mississippi but for Tennessee's pumping. Like its previous lawsuit, Mississippi is treating the water in the aquifer as Mississippi property, not as an interstate resource, and is asking for damages for the water Tennessee has taken. So in this case, the court has appointed a special master who is now running a trial-like process. So the parties have submitted briefs on initial motions, and oral arguments have yet to be scheduled. And a threshold issue in this case is going to be whether the special master agrees with either Tennessee's theory of the case and determines that this should be treated as an interstate water dispute, or with Mississippi in determining that the state would be entitled to monetary damages.
So do we know how the U.S. Supreme Court will rule in the Florida versus Georgia case?
So the court has stated that equitable apportionment is a flexible doctrine, and it will consider all relevant factors of the case, as well as the harms and benefits to each state, so that a just result is reached. The doctrine's basis, as I said before, is that each state is entitled to the quality of right, not equal amounts of water. So in the previous cases, the courts have given these factors that will inform its decisions. So these factors are physical and climatic conditions, consumptive use of water, the character and rate of return flows, established uses and economies built on them, the availability of storage water, the practical effect of wasteful uses on downstream areas, and the damage to the upstream area compared to the benefit to the downstream area. So when we're thinking about Florida versus Georgia, the court's really going to be considering if Atlanta's need and use of the water is outweighing this harm to the oysters in Florida. And the court's going to be considering is what is happening is fair. And so courts have traditionally given cities more leeway in providing water than they would have for individual users. So I do think the fact that Atlanta is this major, still growing city will play a significant role in the case. As well, whether Florida can convincingly connect Atlanta's use to the damage to the oyster industry in the state. This case is actually finally moving, I will note, and that as of right now, the trial is supposed to start on Halloween of this year.
Well, how about in Mississippi versus Tennessee? How do you think the court will rule in that case?
So many of the factors that we just went through actually deal with characteristics of surface water and not groundwater. So it's therefore kind of difficult to protect precisely how the court's going to apply its prior decisions to Mississippi versus Tennessee. But again, equity is going to be a major factor, along with which state needs the water the most now and for what purpose. So it could be that Memphis taking a lot of water from under northern Mississippi is okay if Memphis needs the water now. It's all going to depend on what the court thinks is fair. But as I stated before, a threshold issue in the case will be whether the court accepts Tennessee or Mississippi's theory of the case. That is whether the aquifer is an interstate water that needs to be apportioned, or whether Mississippi owns the groundwater within its borders and is entitled to monetary damages. So in February of this year, Tennessee submitted a motion for a judgment on the pleading, arguing that the case should be terminated since Mississippi has not asked for an apportionment. So once the special master kind of decides this motion, we'll have a better understanding of how the case will and will not proceed.
All right. Well, let's move on and talk a little bit about the research you've done on the Safe Drinking Water Act. Can you explain a little bit about what the Safe Drinking Water Act is?
Sure. So Congress enacted the Safe Drinking Water Act back in 1974 and amended and reauthorized it in 1986 and 1996. It's the main federal law that ensures the quality of American drinking water. It authorizes the U.S. Environmental Protection Agency, the EPA, to set national standards for drinking water to protect against health effects from exposure to naturally occurring and man-made contaminants. And it's an example of what is called cooperative federalism. So while the U.S. EPA is running this program, it's working with the states, local governments, and water suppliers to carry out these standards. And then finally, it's requiring these water systems to inform their consumers through what are known as the CCR reports about contaminants in their drinking water and violations of the law.
So what water is covered by the Act?
So public water systems are what is regulated under the Safe Drinking Water Act. So public water systems are those having at least 15 service connections or serve at least 25 people for at least 60 days a year. drinking water standards may apply differently based on the type and size of the public water system. So these systems must ensure that the water they provide meets health standards established by the EPA, and they have to test the water according to schedules in the regulation. What's important to note is about 10% of the people in the United States rely on water from private wells, and private wells are not regulated under the Drinking Water Act. So those who have private wells need themselves to take precautions to ensure that their drinking water is safe.
How is it determined what contaminants are covered by the Act?
So, through the Act, Congress directs the EPA to adopt regulations for contaminants in drinking water that can adversely affect health and that are known or could occur in public water systems. So, under the Act, EPA is to establish what's known as maximum contaminant level goals, and then promulgate regulations to kind of reach those goals. So for each contaminant, the Act directs the EPA to set this, again, what I said is a maximum contaminant level goal, and these are kind of non-enforceable public health goals. They're more aspirational. And then the next step is what they do is to set a maximum contaminant level, which again they set by regulations. And these are the levels under the Act that are actually actionable. But in addition to kind of the health risk analysis that they would set in that aspirational goal level, the EPA can actually take feasibility and cost into account in setting these. So the example that's easiest to give is that the NSGLC for lead is actually 0 because there's no safe level of lead for us. But the action level under the Act is actually higher than that because it would not be feasible for water systems to take all lead out of the water.
And what happens when a contaminant level is exceeded?
So first, the treatment actions that the water system has to take is going to depend on the particular contaminant. So it's going to be done by regulation. So then public water systems are also required to provide notice of violations to persons served by the system. And so the time period for which this notice must be provided depends on whether the violation is a Tier 1, Tier 2, or Tier 3 violation. Tier 1 violations are considered immediate threats to the public and require notice within 24 hours of learning of the violation. The Tier 1 violations include MCL violations for contaminants like E. coli, nitrates, chlorine dioxide, and turbidity, as well as outbreaks of waterborne diseases. The notice is supposed to be given in a form that can reasonably reach all persons served by the system, such as through the radio or TV or posting notices throughout the area. So you may have seen one of these notices when you or maybe been issued a boil water notice for your house. So that's kind of the kind of Tier 1 violations that happen. Tier 2 violations require notice within 30 days. And so this notice is mostly done through the mail, and it covers most MCL violations as well as some monitoring and testing violations. And the example here is, for instance, lead violations only require notice within 30 days, not immediately. And so finally, Tier 3 violations require notice within 1 year, and it can be given through that annual notice, that PCR report, and it covers things like monitoring and testing violations, record-keeping violations, and those kind of things that aren't any kind of threat to the public health.
Okay. Who handles enforcement under the Act?
So under the Act, EPA has established standards that public water systems must meet, and then delegated to the state's primary enforcement authority. So states that meet certain requirements are who regulates the public water systems in their states. The EPA still does play somewhat of a role, however, in the enforcement of these regulations. So under the Act, when the EPA discovers that a state is not meeting the requirements of the Act, the EPA administrator is required to notify both the state and public water systems of the violation and provide assistance to bring the system back into compliance. If the state does not act after 30 days, the EPA administrator is supposed to order the public water system to comply, or the agency will institute a civil action. The EPA also has emergency powers under the Act, so these actions can include in order to protect the health of the public water system's users, including requiring providing alternate water supplies, and also bringing a civil suit.
Can private citizens sue under the Safe Drinking Water Act?
Sure. So individuals can file civil actions against any person in violation of the Safe Drinking Water Act. The EPA, where there is a failure to perform any non-discretionary act or duty, or any federal agency who fails to pay a penalty under the Act. So with the Flint crisis, we've seen many suits filed, and we've also seen class actions in cities like Philadelphia for lead violations. I'm also going to talk about in a little bit how the Drinking Water Act is playing a role in a nutrient management case with the Des Moines Water Works.
Yeah, so as you mentioned, Flint was major news earlier this year. How is lead regulated under the Act?
So under the Act, the EPA has issued regulations covering lead and copper contamination in drinking water, known as the Lead and Copper Rule. The rule focuses on keeping lead from plumbing from getting into the drinking supply. So since a lot of lead exposure is actually caused by lead leaching out of old plumbing, the rule requires the use of optimal corrosion control treatment. So one such treatment option is determined by the state through the process described in the rule. The system is required to install and operate this corrosion control throughout the distribution system. As I said before, EPA has set the NSGLC for lead at 0, since there's no safe level of exposure to lead. However, under the rule, the EPA has set the action level for the concentration of lead in more than 10% of tap water samples collected during any monitoring period at 15 parts per billion. So the monitoring of lead is done through sampling of household tap water, and these samples are supposed to be collected from sites that are more likely to have lead in their plumbing materials.
And what happens if the action level for lead is triggered?
So first, the water system is directed to take further action to optimize its corrosion control treatment. The system is also required to engage in public education, including providing information about the presence of lead in drinking water and the actions that consumers could take to decrease their lead exposure. And finally, the system is directed to replace lead service lines under its control.
So can you talk about some of the issues that happened in Flint?
Sure. So the major issue in Flint had to do with the decision not to institute corrosion control immediately when the city switched from Detroit to Flint River water. So at the time of the switch, the Michigan Department of Environmental Quality did not require that this optimal corrosion control be instituted at this time. Rather, it only required that initial monitor of the water be required. So this decision allowed the water from the Flint River to corrode lead plumbing in Flint, causing lead to leach into the water. Another issue in Flint was how the sampling of the city's water occurred after the city switched to using the water from the Flint River. So under the rule, samples are supposed to be collected from sites that are more likely to have lead in their plumbing materials, which the water system is directed to identify in order to have a sufficient pool of targeted sampling sites. However, there are allegations that Flint's water system did not meet these requirements, as the system collected samples without regard for whether the site contained lead plumbing or was served by a lead service line, nor did it identify a targeted sampling pool or even know where the lead service lines are located in the city. And by not meeting these sampling requirements, the city water system could have really affected whether the water samples met the lead action level. So this map is showing on the left kind of what the sampling was done by Flint. And then on the right is actually where the sampling happened by the researchers by Virginia Tech, who showed much higher levels of lead in the city than the city's water system monitoring had done. And so finally, there are questions concerning whether EPA exercised its emergency powers quickly enough once it learned about the lead levels in Flint.
Thanks. So let's move on and talk about nutrient pollution regulations. What is nutrient pollution?
So nutrient pollution is one of America's most widespread, costly, and challenging problems facing our waterways. Human activities primarily cause nutrient pollution, and agriculture is one of the largest sources of nitrogen and phosphorus pollution. While nitrogen and phosphorus are natural parts of aquatic ecosystems, too much of these nutrients can cause algae to grow faster than an ecosystem can naturally break them down. This significantly decreases water quality and creates what are known as dead zones. So there isn't enough oxygen in the water for fish and other organisms to survive. So the issue most people think about and what this map is showing is nutrient pollution in the Gulf of Mexico dead zone, and as well as other dead zones that form throughout the country, such as through the Chesapeake Bay. But recently here at the Law Center, we've been looking at kind of how nutrients are regulated under the Drinking Water Act.
And what are the dangers of nutrients in drinking water?
So while millions of Americans use nutrient-polluted water as their drinking water source, Such pollutions create toxins and compounds which can be harmful to human health. So drinking or swimming in nutrient-polluted water can cause rashes, stomach illness, respiratory problems, and neurological effects. And infants can actually become seriously ill or die from drinking highly nitrated water, through what's known as blue baby syndrome, because it kind of cuts down on their ability to get oxygen throughout their body. And because agriculture is one of the largest sources of nitrogen pollution, individuals living in surrounding areas often have nitrate-polluted drinking water, and those wells are particularly susceptible.
So how are nutrients regulated under the Safe Drinking Water Act?
So while nitrate is considered a contaminant under the Act, phosphorus is not. So phosphorus is not regulated at all. The NSGLC and MCL for nitrate are 10 milligrams a liter, and that is the same level for nitrate, and so as well as the total nitrate and nitrate levels. The public water systems are required to monitor for these MCL compliances, and so for nitrate, the groundwater must be monitored annually, while surface water must be monitored quarterly.
And are there any current civil suits involving nitrate violations?
So currently there are no cases under the Drinking Water Act enforcement provisions concerning nitrate. However, the Board of Water Works trustee of the City of Des Moines, Iowa, which is commonly known as Des Moines Water Works, has used the nitrogen provisions of the Act to establish its standing to bring a citizen enforcement action against 3 Iowa counties for the discharge of nitrate pollution into the Raccoon River without a National Pollution Discharge Elimination System, or NPDES, permit in violation of the Clean Water Act. So the Des Moines Water Works is a regional water utility who obtains its raw water source from the Raccoon River, and under the Act, it's obligated to meet the nitrate MCL. So Des Moines Water Works claims, despite constructing a $4.5 million nitrate removal facility with an approximate daily cost around between $4,000 to $7,000, and implementing strategies to control periodic high levels of nitrate in the river, nitrate continues to threaten its water supply and its ability to deliver safe drinking water. So in the future, the Water Works is actually claiming it expects to expend between $76 million to $183 million to increase its nitrate removal ability and capacity. So while the suit itself isn't under the Drinking Water Act, because there hasn't actually been a violation of the Act, the Water Works is using its duty to treat its water with high levels of nitrates as how they are establishing standing in the case.
Thank you, Kathy. Where can we find more information about all of this?
So if all of this was too quick to go through, I was actually asked on campus this past fall to give a TED talk on water scarcity and water law issues. And so that link is here on the screen. If people would like to hear 12 more minutes about how we allocate water and how we kind of deal with interstate water disputes.
That was very good.
And then I also had, been asked on campus to talk about some kind of drinking water issues, and have actually written an article about the Flint water crisis and what's going on with the Drinking Water Act in our publication, Sandbar, which is also located on our website.
Great. Thank you, Kathy. And I think now we'll open it up to questions.
Yeah, thanks, Kathy and Tara. And so if anybody on the line, if you have questions for Kathy, feel free to use the chat box. And while people are thinking about their questions, I also wanted to mention that, of course, the National Sea Grant Law Center has a number of resources available to the Sea Grant Network, and we wanted to share the information about what Kathy has been working on to kind of pique your interest in water issues and how the National Sea Grant Law Center might help address some of the questions that you and your stakeholders might have. Certainly some of the Safe Drinking Water Act issues that Kathy talked about today are also relevant when there's a harmful algal bloom, that a similar, some of the standards and the warnings come into play with that. So I encourage you to, think about if your program is working on issues related to water, and legal questions or policy questions are coming up in your work, to remember the National Sea Grant Law Center's advisory service, which is our research service that's provided free of charge to the Sea Grant program. And we're happy to talk at any time about the questions that you might have and whether there's ways that we can help either through legal research memos or fact sheets, or as Kathy mentioned, she's been giving a number of presentations in different venues. So, here's a couple of questions coming in. So Kathy, one person is asking about saltwater intrusion and the relationship to subsidence.
Yeah, so subsidence, could happen with or without saltwater intrusion, but the problem it's causing is that we're pumping the water out from underneath the ground. That support for the ground is actually causing the ground itself to sink. So subsidence could happen any place, whether or not it's related to salt water. But if it's also next to some place where there's salt water, that excess pumping could cause both subsidence and the salt water to actually be drawn into the aquifer and contaminate the aquifer in that way. If that answers their question.
I don't know, Kathy, I was wondering have you come across, do any of the groundwater, are they even connected, I guess, like groundwater management, would they be worried about subsidence?
It's not something that necessarily comes up a lot, but actually in Texas, which has the most liberal, I would say, groundwater rules. So in Texas, it's the rule of capture, which is this extreme doctrine. It's only followed by Maine, and it's kind of saying that anything you can pump up from underneath your property is yours, and you own it completely. So even in Texas, if your neighbor can show that you kind of maliciously pumping that groundwater and cause subsidence on their property, you would actually be liable for that. So in some circumstances, it could be a liability issue with your neighbor. I wouldn't necessarily say the states or locales are really considering it when they're giving out water rights to people.
Thanks. Anyone else have questions? No? Well, great. And just want to let folks know, I know a few people joined late. We are recording the webinar. We do post them on our website. After webinar usually comes up in about a week. And so feel free, to take a look at the recording and also to share that with other people in your office that might be interested. And again, I thank everyone for joining us today, and I hope you'll join us next month when we're going to be talking about our graduate program, the work that we do with law students across the country. Thanks.